Further hearing in the appeal of Kadian, Jamaica and Congo against the Secretary of State for the Home Department.
My Lords, my Lady, before Mr. Beloff continues, can I draw the Court's attention to some documents that have been handed up this morning? In the course of my submissions, I agreed to provide certain documents to the Court. And what you, I hope, have, or will shortly have, are three groups of documents. The first is headed Submissions on behalf of the appellants, the unpublished policy and lack of candour.
Yes.
That is the merged document. It's what has been described as Annex B, together with the submissions that were in Annex 5. And the points there are grouped under the same headings that appeared in Annex B. And for each paragraph, there's a statement of where it's derived from. So, for example, if one goes to the introduction, paragraph 3 is drawn from the supplementary submissions. Paragraph 5 is drawn from the original Annex B. So one can trace where it comes from. That is dealt with thematically as the original document was. My Lord Brown did, I think, request that the exercise should be done chronologically. The difficulty we encountered doing that when trying to merge the two documents was that one would then produce a completely different document.
Yes.
So what we've done is produce a chronology of the references which appear in now the merged document. And that, I hope, is self-explanatory. Date, the event and document. The page reference, which also includes the date on which any document was disclosed, and then the reference to the new submissions.
Yes.
The third group of documents is I think, in response to a request by my Lord Roger, was a clip of the ministerial statements.
Thank you very much.
The one thing that's missing from that, because it would be difficult to copy it, is the article by Dr. John Reed in the Sunday Express, which your Lordships will find at 1199 to 1200.
Thank you.
If you need it. And then finally, while I'm on my feet...
Sorry, could you go to the page numbers again?
Yes, it's 1199 to 1200, and it's in Appendix 2A.
Thank you.
Finally, while I'm on my feet, there's a fourth document produced by Mr. Hussain in WL's case only, and it's in response to the point raised by my lady on the first day of the hearing, I think, concerning the deportation proposal. And I say no more about it.
Thank you very much. Those documents will be very helpful.
Please, my lords and my ladies, four preliminary matters, if I may, before continuing down the route indicated in the respondent's propositions document. First, my Lord Hope persuaded me gently to add to paragraph 1 of the propositions the concept that we were obliged as well as entitled to have a policy. My Lord, I prefer, if I may, to reject that invitation with retrospective effect. It doesn't arise in this particular case, in this particular area. It has always been the Secretary of State's position that policy, there should be a policy, and there is a policy. There are wide implications that don't arise in this case, and I prefer not to have committed the department to anything wider than I put in the original propositions. Thank you. My Lord, my Lady, secondly, there were two matters raised by my Lady Hale. The first, I can assuage her concerns, or perhaps more accurately, assuage my concerns in response that I provisionally gave to her about whether there was any difference in terms of substance or indeed a parliamentary procedure in relation to schedules to an act as distinct from the provisions of the act itself. We have canvassed the usual authorities, Benyon, Crace, and of course Erskine May, and the short position is that it has been said on several occasions that a schedule in an act is a mere question of drafting, a mere question of words. The schedule is as much a part of the statute, as much an enactment as any other part, the august words of Lord Justice Brett. And in relation to the parliamentary process, all that happens is that a priority is given in terms of amending two clauses, and schedules are amended thereafter, but they are amended in exactly the same way. So if we may, we'll hand in the documentation to
Can someone, as it were, identify a paragraph within a schedule and propose an amendment directed to the paragraph?
Yes, it doesn't appear that there's any reason not to do so.
No objection to that?
No objection to doing so.
Right.
Okay. What is said is, in Erskine May, after amendments, clauses of the bill are being considered, new schedules may be proposed and amended in the same way as new clauses. The second matter raised by my lady was the question as the difficulty of drawing a dividing line between a presumption of liberty in substantive sense and the shifting of the burden of proof. And we were reminded of what I hope was the case that my lady had in mind, a case in the Court of Appeal presided over by my Lord the President, the RH and MRHT case, which I hope we have copies of. Because in our submission, as those are being distributed, actually on true analysis, that is another case which is entirely to do with the shifting of the burden of proof and whether or not that was compatible with the convention jurisprudence. What there were certain criteria which dictated whether or not someone should be detained, and the issue before the Court of Appeal was whether or not the onus lay upon those who wished to detain to show that those criteria were satisfied, or whether the onus should be placed on the potential detainee to show that they were not satisfied. And the resolution was that the provision had to be, was incompatible because my lords decided that it was not capable of being read down. Yeah, for me. Thank you very much indeed. If you go to, my Lord Sir John Dyson was also a member of this court, and I hope this is the one we had in mind, because Mr. Binder Singh very kindly identified this as being one of the rare cases in which he was unsuccessful in his submissions, and he was indeed counsel in that case. So if one looks then at paragraphs 12 and 13, one sees what the substantive provisions were, that a tribunal could direct discharge of a patient liable to be detained if they're satisfied, and then certain criteria are then set out, the mental illness, psychopathic disorder, etc., etc. And then the issue was debated under the general rubric, burden of proof, as one sees at page 9 of the judgment of my Lord the President, then the Master of the Rolls. And the issue was canvassed as to whether or not it was possible to read down the section which appeared to impose the burden of proof on the patient to be detained. Mr. Singh advanced the argument on behalf of the Secretary of State. The court said they were not persuaded by this submission, and perhaps taking up the third sentence in trenchant language, we do not consider, however, that such an approach, that straining the statutory language, enables us to interpret a requirement tribunal must act as if satisfied a state of affairs does not exist, as meaning that it must act if not satisfied that a state of affairs does exist, and then one sees winter work and so on, and the conclusion being, as my lady recollected, that the provisions as then drafted were incompatible with what's described as the seminal European Court of Human Rights case. Now, we again say this is entirely distinct from the policy presumption in issue in our case. It has affinities, of course, with that which was debated in the Harrow Crown Court case, which my Lord Brown took a leading part in the judgments that were delivered. The type of policy which we're concerned about has nothing to do with governing the burden of proof. There's no parties, there's no adversarial argument, there's no need for a default position as one might have in contested litigation in which there's a total absence of evidence, and therefore the court has to evaluate what the conclusion should be. We are here concerned with what confines are there to an administrative decision, and we submit, for the reasons that I developed before the adjournment, that there are no confines such as are indicated or canvassed in these submissions on behalf of the appellants and with the support of justice and of bid. The final matter was a question raised by my Lord Brown about bail in the context of immigration detention, whether there were any principles, and if so, what they are. My Lord, what we have been able to ascertain through the industry of my juniors is a speech given by Mr. Justice Blake, obviously someone highly experienced in this area, to a conference of immigration judges in June of this year. And the short point is that he said, in the context of the provisions that we looked at before the adjournment, that Parliament has been signally unhelpful in giving any kind of indication as to the way in which, in that context, as distinct from the criminal context, judges seized of an application for bail should determine it. He expresses the view, again, that those who hoped for a solution from Article 5 would be disappointed in the decision given in the Sardi case. He described that as being a substantial blow to those who believed that one could therefore necessarily inform the power to grant bail with a presumption of liberty. And what he in effect says, in order to achieve some degree of coherence in the way in which the immigration judges perform that sensitive task, the senior judges should give guidance, and of course guidance can be given as long as it is rational guidance. So the answer is that one gets no elucidation or assistance from that particular area.
You're putting that piece of paper in?
If your lords and my lady would find it helpful, we'll have it copied. It's already in. Oh, I'm told by Mr. Hussain this is already there. Perhaps we can have the reference given to you in due course.
As far as we expected, the bar knows what's in these 45 odd volumes.
Yeah, well,
Tabs 368.
I'm told it's tab 368. I hope I may be forgiven for having overlooked it in my preparation for this case. Volume 36. And I hope you'll be able then to check that I've fairly summarised the way in which Mr. Justice Blake put the matter. So we come then, if I may, to proposition 6 in our submissions. And again, in our respectful submission, there is nothing that is controversial until one comes to the clause at the end. I remind you that the proposition is that it's accepted a detainee would be entitled to challenge the varies of the unpublished policy by way of an application for judicial review, and subject to satisfying the procedural preconditions of such application and to the court's discretion, obtain appropriate declaratory or quashing relief in relation to that policy. That's all Hornbook law, all uncontroversial. And then we say, controversially, non sequitur, that will be able to obtain damages for false imprisonment as well. Submissions we develop under proposition 9 and 10, to which I shall come very shortly.
Isn't there something in between there? You say that you could get relief to quash the unlawful policy.
Yes.
Could he also get habeas corpus to be released?
This comes back into the issue of causation I shall be developing later. As long as he can show, obviously, that he has been detained on the basis of something that is A, unlawful, and B, has caused his detention, the answer would be yes. But that simply resurrects the questions that I'm going to be dealing with at a later stage. I mean, either I'm right there or I'm wrong there, but I'd be wrong across the plane. My lady is quite yes. Right.
The two go together.
The two go together.
Yeah.
Proposition 7, again, I hope, again, to clear out to distinguish between the common ground and the battleground. The tort of false imprisonment has two ingredients: the fact of imprisonment and the absence of lawful authority to justify it. So far, so good. The onus lies on the déteneur to establish justification. No issue between the parties there. That onus is satisfied if the déteneur can establish that a statutory power to detain the detainee was exercised in relation to him. And then what is here in issue is that the onus then shifts to the detainee to establish that the authority to detain should be treated as vitiated because of some wrongfulness in the exercise of the statutory power. Now, I can take this to some extent quite shortly because Mr. Hossain realistically accepts that the cases that we have cited in paragraph 611 of our printed case, which your Lordship and my Lady have at page 33, all vouch for the proposition that we espouse in that last sentence of paragraph 7, although he fairly says that it does not appear from the reports that there was any dispute as to that. In our respectful submission, of course, it's hard to accept that in articulating at any rate the proposition that I'm going to seek to qualify or assail at a later stage, when Lord Diplock used the concept of showing that it was necessary to show that the behaviour of the detaining or arresting officer was unreasonable, that he did not have in mind, in using that particular adjective, that the obligation to show the unreasonableness did lie on the person who challenged what was on the face of it, otherwise a lawful exercise of power. That choice of epithet suggests a conscious decision as to where the onus was to lie.
Could I ask you, just for clarification, looking at paragraph 7 and going back to the point that you mentioned at the very beginning about paragraph 1,
yes.
Because the focus in both the, I think it's the third sentence and the last sentence, is on the statutory power.
Yes.
Now, I thought that part of the argument against you was that the statutory power is explained by the policy.
Yes.
And the argument is not so much about the statutory power in itself, but the application of the policy.
Yes.
Now, those words are missing from 7, and I'm not sure quite where they come in at all in your submission. Are you just discarding the policy point at this stage and simply looking at the wording of the schedule in the Act, or what?
Yes, I'm going to revert to this when I come to deal with propositions 9 and 10.
I see. But for the moment, we're concerned simply with what the Act provides, are we, in paragraph 7?
Yes, I mean, what we are saying is, in truth, this statutory, the power to detain here, if one asked under what power was the two appellants detained, we would point to the statutory power. We would say that vouches for their detention. The issue then becomes whether we are able to adhere to that proposition in the light of the fact that there was a policy that we have accepted to be unlawful. And that the focus becomes the degree of connection or link between that admittedly unlawful policy and the decision to detain. That's what this appeal pivots on in respect to the generic issues. And I'm going to explore, if I may, at a later stage, whether that sufficiency of that link has been established.
Yes,
but we say at the moment simply that it's for them to establish the link. We also, if I may just pursue the question of the onus, we say that it is consistent with general principle that he who asserts must prove. On the assumption that cases of this kind will conventionally be located in the administrative court, but it may make little difference if it were elsewhere, if a challenge is made to the exercise of an administrative power, that those who wish to assert it have to put that in their claim, and they have to pass the filter of a permission stage at that juncture. Obviously, there are now procedural devices, the sending of a pre-action protocol letter, the response, the summary grounds of defence, and if permission is granted, the obligations to disclose, which may supply, as it were, the evidence that the claimant needs. But no one has ever suggested it isn't for the claimant to, as it were, vouch for their particular claim. And indeed, in the public law sphere, one has, in our respectful submission, a general presumption of regularity. If one looks at the cases that my learned friend relies upon for contrary argument, we deal with those at paragraph 8.22 of our printed case at page 48. And we adhere to the proposition that in all those cases, what the courts were concerned with were what were either statutory or common law conditions precedent to the exercise of the power to arrest or detain. Now, Mr. Hussain said that he had a trump card because the Langley case was not such a case, while accepting the other cases no doubt did fall into that category. He said Langley was a case of an exercise of power and not concerned with its existence. And that's why, recognising that with respect, that's why we used perhaps the ambiguous phrase that it was in effect an emergency protection order was in force. It was in effect mandatory to use those procedures in the circumstances. Can we just return to look very briefly at Langley, because I need obviously to engage with that particular point. Although one notes that whether we are right in saying that my Lord Sir John Dyson came as close as one could anticipate to effectively saying you cannot do this unless something happens, which is, as it were, applying to the statute the kind of restraints that one has in this area, concerned with hard you'll sing. It wouldn't matter if we were wrong, because it's common ground between the parties that the issue of whether or not, in consequence, damages for false imprisonment would flow was never actually debated. But if we just go back to Langley, since my learned friend rightly says it could be classified as being in a different category to the other cases, and goes straight, since you've already seen this, to paragraph 38.
No, it's 153 and it's in volume...
It's 148.
148.
148, I beg your pardon. And volume...
Which volume is it?
I'm so sorry.
Just that you had 153 in your case, but...
Oh, I'm so sorry.
but,
yes,
that's
I've noticed that. I'm not entirely certain. I think, alas, that so much was generated. This predated the final listing of the authorities, and from time to time I found myself embarrassed in my overnight research in tracing what it was I was meant to be rereading. Just looking very, very closely, swiftly, if I may, at the way in which my Lord dealt with the matter, he was concerned with the juxtaposition between the Section 46 and Section 44 regimes, that which the Council had to do with the court and that which entitled police officers to remove in situations of emergency children from their families. And he determined that the statutory scheme accorded primacy to Section 44, not least because it required the sanction of the court and for other reasons. And then, against that background, he went on to hold expressly, I would therefore hold, paragraph 40, that removal of children should usually be effected pursuant to an EPO, and that Section 46 should be invoked only where it is not practicable to execute an EPO. And that comes close in our respectful submission to simply a question here of statutory construction, saying there's primacy, that's, as it were, has to go down the route first. But then qualified in a certain way at paragraph 44, it follows from the analysis above that Sergeant Jones had jurisdiction to remove Callum pursuant to section 46, were there compelling reasons for exercising this power when to his knowledge an EPO was in force which authorised the council to remove Callum into the care of foster carers, and my Lord then concluded that there were not. In paragraph 45, he said that what the Sergeant Jones should have done was to ask the council to execute an EPO, an emergency protection order, and would only have been justified in using his more draconian powers under section 46 if they had declined to do so. There were no compelling reasons in paragraph 46 to exercise that power in those circumstances. Accordingly, the removal was unlawful. Now, I appreciate that my Lord articulates this in a manner that suggests, yes, jurisdiction, but no, it's mis-exercise. But my Lord came as close as may be to, in effect, construing the statute in a particular way, as if it read, you can only exercise these powers if there are compelling reasons, and not wholly distinct from the way in which the court in Hardyall Singh also, as it were, implied into a statute. But as I say, were this to be properly construed as distinct from the other cases concerned with exercise, not extent, it matters not for the purposes of the argument before my Lord, because it's common ground, as I said at paragraph 48, that there was no debate as to whether the consequence would be that damages for false imprisonment would ensue. Just dealing then, if I may, with the way in which my learned friend put his case, he handed in a document on burden of proof. Do you have a copy of that, Steve? Yeah. Just taking the passages that he referred, the submissions that he made in that document shortly, we don't dispute, obviously, at paragraph 4, which is acknowledgement that our submission has judicial support, and we don't dispute that the point doesn't appear to have been the subject of...
Sorry, could you just stop a moment, because certainly I, at the moment, can't find my...
sorry.
I may not be the only one who's in that position.
Well, actually, I was in my Lord's company a moment ago. Mr. Tam rescued me with his usual agility.
Oh yes, I found mine now.
Sorry, can you outline the submission?
It's heading...
Yeah, you got
Burden
burden of proof.
Yeah, I got that. Well, no, can you go back to where you started and talking about it?
Yes, 4. Paragraph 4 is the...
I'm sorry, I don't think I have
Oh,
that.
well, Mr. Hussain has plenty of spares.
I'm sure he has plenty of spares.
Early for Christmas.
Do you know what we're looking for?
When did this document come in?
It was produced by Mr. Hussain, it seems a lot.
Oh, yes.
Monday afternoon.
Yes, it's
After midday German on the first day. Just going then to paragraph 4, our response to that is, yes, we accept that the points do not appear to have been argued, but we do stress that in using the vocabulary of unreasonable, Lord Diplock was clearly envisaging, consistent with ordinary principle, that it would be he who avers that there's been a misuse of power must establish it. 5A, we've already debated the true meaning of the principle in favour of the protection of liberty in Liversidge, and there is a debate between the parties which I won't re-engage. In relation to Annie's Minnick, in our respectful submission, even if Annie's Minnick has amalgamated the various grounds for judicial review and the distinctions drawn between various types of illegality in public law has been eroded. Nonetheless, if one makes an Annie's Minnick challenge, one again has to assert the kind of illegality that one relies upon. The difficulty of drawing a boundary one can accept, but there is nonetheless a boundary. In a case in which it is asserted that the Hardiel-Singh principle that the time for detention must be reasonable and not extend beyond a reasonable period, in our respectful submission, it remains for the claimant to make good that particular assertion. And finally, in relation to the difficulties that are said to be incumbent upon or to burden a detainee who would have less knowledge of the reasons for his detention or might than the detainor would have, in our respectful submission, that is no different from a proposition that could be advanced in any case of an assertion of a misuse of power. Again, one returns to the orthodox position that he who asserts a matter of this kind has the prima facie obligation to establish it. Under 6 refers to the ECHR rights and other rights. One needn't explore that territory in our respectful submission because the European Court of Human Rights has pronounced on the particular article, and nothing said in Shahar or Sadi supports the analysis that my learned friend there says. The Secretary of State can simply point to the statutory powers, can, if he chooses to do so, say they are justified in Hardiel-Singh terms, and nothing in the European Convention obliges him to do more. 7, the case of Zavarenos was not in fact provided by my learned friend, but actually it was a case that we referred to in our own printed case at paragraph 9.32 at page 58. And it's an unpromising start for my learned friend, whatever it said, because it's one of a host of cases from both Australia and from New Zealand, in which the ruling in Holgate Mohammed, that's to say whether an arrest for the purposes of investigation or questioning is lawful at common law, was actually rejected. The Antipodean courts take, if I may put it in this vocabulary, a more libertarian line, it may be, than the English courts have hitherto. But anything then said about the burden of proof, in our respectful submission, is conditioned by the starting point. So we are respectfully submitting that we go back to the question, the ordinary question, he who asserts must establish. And indeed, when one is in the context of judicial review, in the end, perhaps the vocabulary of burden of proof is a little deceptive. One isn't only infrequently evaluating the weight of evidence one side or the other. One is simply looking, as is usual, at a series of agreed facts and asking whether they establish some form of illegality or not. 2 further points on false imprisonment as a tort. The fact that it is a tort of strict liability tells one nothing in our respectful submission about its ingredients. All it tells one is that one doesn't need to establish damage to establish the tort. That's its solitary, though useful, function. And nor, may I add at this stage, I've referred to this at a later stage, the fact that one doesn't need to prove damage to establish the tort automatically mean that one is entitled to more than nominal damages if one in fact has suffered no damage. But I'll return to that.
Strict liability doesn't usually mean that you get that it's actionable per se. I mean, there are plenty of strict liability torts in relation to physical injury and so on, which you wouldn't get any damages unless you suffered injury. I mean, it's not. I don't think strict liability carries that particular implication, does it?
Well, I've always understood. I mean, sometimes when one talks about strict liability in other areas, one says lack of mental element. There isn't a question of lack of mental element here. One has, indeed, as it were, to intend the act, which is the act of imprisonment. No, I don't think I'm disputing what my Lord says. All I'm saying is that's what the definition is, and all it means is you don't. The pleaded case will be complete without a plea and has accordingly suffered damage. That's all. And I don't understand my Lord and I to disagree on that, which is a merciful relief to me. Can we then go to paragraph 8? That, again, in our respectful submission, is not controversial. It's vouched for by the very same cases that Mr. Hussain cited, and we responded to at page 48 at paragraph 8.22. All are cases in which, save for Langley on one view, a condition precedent to any exercise of power was not satisfied. The true analogy in the present case would be if the Secretary of State had detained the appellants without forming a view that their deportation was for the public good, and without forming a view in consequence that he should implement the machinery of deportation. So that could be at the start, or at the end, in detaining someone at a stage where there was no longer any prospect at all of removal.
Paragraph 8 is simply saying that the legal burden is always on the defendant, but there's an evidential burden on the claimant. Do you accept that?
Yes. Yes. I mean, just the two instances I gave by way of analogy, the first, you would lack power entirely. You hadn't even got into that area in which Parliament has given you the power to detain. And the second, which I gave, detained when there was no longer any prospect at all of removal, because that again would violate the Hardiel-Singh principles, because you would be no longer detaining pending removal, because removal was never on the facts then going to take place.
I'm sorry, Mr. Bell, I mean, the Hardiel-Singh, is that part of the statutory power? I'm just going back to 7, sentence 2, or sentence 3.
Yes.
The onus is satisfied if the detained organ established that a statutory power to detain was exercised. Is that just the condition precedent, or does that include the Hardiel-Singh?
No, I think, no, I don't say it would include the Hardiel-Singh.
But you do when it comes to A.
No. Hardiel-Singh lays down, in essence, two matters. First of all, you can only detain for the purposes of removal. And secondly, that you cannot detain at the time when removal is no longer in prospect. And thirdly, no doubt that you cannot detain beyond a reasonable time. In our respectful submission, any of those matters would have to be raised by the claimant. He would either have to say, you're not detaining me for the purpose of removal, but for some collateral or other purpose. You no longer have any prospect of being able to remove me, or in any event, the removal has exceeded a reasonable time. Our position would be that in all those matters, the onus would be upon the claimant.
Well, then, to accord with 7, ought 8 to say if the detainer has no power to detain, or if the authority to detain is vitiated by some wrongfulness, i.e. violation of the Hardiel-Singh principles.
Yes, but the Hardiel-Singh principles were seen as a point, as it were, there was an issue of construction of the statute. That's how they were articulated and how they've been held to be.
Well, I'm still a bit unclear. I mean, it's one of the points I raised with you earlier, just what the scope of the discussion is in 7 and 8. Because I thought you said to me, in answer to my question, that it was entirely focused on the provisions of the paragraphs in the schedule, and that at this stage in the argument you're not concerned with policy, and now you're saying Hardiel-Singh doesn't apply either. Is that right?
I mean, Hardiel-Singh, as we understand it, is a view taken by the courts as to what one should read as implied into the statutory provisions Therefore, one reads it as if it said more elaborately, thou shalt not detain otherwise than for the purpose of removal. Thou shalt not detain accordingly at a time when removal can no longer be in prospect of being effected, and thou shalt not detain at a time when the period exceeds the bounds of reasonableness. Now, we say that any of those, if they were not satisfied, they say that's implicit in the power itself. So that I'm accepting, I'm reading in, as it were, those within perhaps the more concentrated phrase I've used. But in all those instances, we would say that it is for the detainee to establish the absence of varies, and that if able so to establish, he would obtain damages.
And the trouble with that is it goes therefore to the existence of the power. And Kadian says it actually goes to the exercise.
Well, that's I'm aware of my Lord's judgment that in that case, perhaps it's a question of classification.
Well,
but our position has always been, as I understand it, that if any of those three elements of Hardial Singh are not satisfied, then in those circumstances, damages for false imprisonment would be available.
But it still raises the issue about the third sentence in paragraph 7, because as I understand your proposition, it's enough for you to say, I can point to the paragraph in the statute.
Yes.
And you're then saying, well, if you want to raise a Hardial Singh objection, it's for the detainee to do that.
Yes.
And do I read that correctly?
Yes.
That's your proposition?
That is the proposition. And indeed, that's how it occurs. I mean, I don't understand it to be said, I'm detained, now it's for you to show that you are actually exercising this for the power to remove. In the, no doubt, extraordinary circumstances in which a detention was sought to be exercised under these powers, but the Secretary of State had an entirely collateral motive, personal malice.
I mean, I have no difficulty with that. It's just that when you then get to 8, actually your concession really has to be if the detainee has no power to detain, or if his exercise of the power is flawed by, if you like, the detainee having proved that he breached the requirements of its exercise in Hardial Singh.
Because they are, with respect, I mean, they have been elevated by judicial authority to being either conditions precedent, what your motive was when you detained in the first place, or conditions subsequent, the reason that you can detain has evaporated, either because you no longer can remove, or because the reasonable time has been exceeded. What I do adhere resolutely to is whether one talks about that as being exercise or extent, the situation is entirely distinct from the situation with which my lords are confronted in this appeal.
I mean, that's what you have to do. You have to distinguish not only the statutory underlying basis of the power, but also application of Hardial Singh, and say, all right, well, those two are in a separate category from the sort of public law breach with which we're concerned here. I mean, that's where you're getting to. You have to get to in your argument on liability.
Yes.
Yeah.
I mean, I have to, without respectfully seeking to demur from my lord's classification in Kadian, simply say the construction that's been imposed by judicial authority essentially says these are conditions precedent. These are they. We're not, in this particular case, subject to the argument that will occur in relation to WL at a later stage in that area at all. Yes, I have that, yeah.
Except might be easier to say it's Hardial Singh is really 9, except of causation often.
Right. But then goes to Proposition 9, which, as Mr. Tam reminds me, in a sense, resurrects the question. If, however, the detainee's challenge is as to the exercise, not the existence of the power, the detainee must establish a causal link between the alleged misexercise and his own detention. So here one would say, even if Hardiel-Singh principles are to be categorized as related to exercise as distinct from extent. Still, in those circumstances, it no doubt be easy to establish, and the onus would be on the detainee, that, to take the most obvious example, there is no chance at all by now of your removing me to Ruritania because I am persona non grata in Ruritania. They have now a national policy not to accept back anyone with these criteria, etc., etc. And then there would be, as it were, the clear causal link between the misdetention if it continued past in those circumstances. What we say here, of course, is that that type of link is simply not present.
But if it was, then what would the conclusion be?
Well, if
back to proposition.
Well, if there were what I loosely call a causal connection or a sufficient connection, then the answer would be yes.
You go back to proposition 8.
Yes, go back to proposition 8. Yeah. It's really propositions 9 and 10 together to which I now come, which actually are the heart of this appeal. And I hope that, in a sense, in seeking to summarise and provide some kind of route map through our case, I haven't, as it were, unduly concentrated the propositions to ignore the fact that really at 9 and 10, it's the point about the causal link on the one hand, or perhaps the more, I won't say exotic, but the more interesting exercise that we say they should damages for false imprisonment should only be available in addition to where the detainee has no power to detain, where the exercise is vitiated by bad faith or improper purpose. Now, the question really at the heart of this appeal is whether persons who are detained in circumstances where the existence of the power to detain is accepted, but its exercise is said to be vitiated by a public law flaw, and we'll put on one side Hardiel-Singh for the moment, entitled to damages, and the starting point of the appellant's case has to be, and indeed is, the dictum of Lord Diplock in Duke and Holgate Mohammed, which is the first case, to our knowledge, which espoused the proposition which is favourable to the appellant's case. So perhaps, if we may, can we just look very briefly at what Lord Diplock said? And again, it may be that the reference in my printed case will be wrong, but it is 63, volume 7.
Sorry, what is it?
Holgate Mohammed.
I know. What's the reference?
Volume 7, tab 63.
At some point, Mr. Beloff, are you going to respond? I'm sure you will, to Mr. Singh's point on this and Mr. Fordham's, because the cases, as I noted them, to which our attention was drawn was Cooper and Davey. But you're going to come back to those at some point.
I'll deal with those.
Thank you.
I mean, Davey and Spelthorne was merely an overview by Lord Wilberforce,
Yes.
who was not entirely sympathetic to the introduction of the vocabulary of public law into our domestic system, to simply say,
yes,
don't assume there is a clear dividing line, yes, between the two. As a decision itself, it's unilluminating, yes, in the context of Cooper and Wandsworth. I shall.
Yes, Cooper is Mr. Fordham's point.
Cooper is of some significance. The dictum of Lord Diplock. My lords will recollect, in this particular case, the defendants were not called upon. The chief constable, the detaineur, was not called upon. So it was quite clearly, in any event, obiter. And it was also, in our respectful submission, not a matter that was argued at all. Firstly, let's just look at what was said. This is at page 443. 443. The statutory power to arrest here, and it was said a condition precedent to the power, I'm using the names out, to take the appellant to custody, and the power of the other constables at the police station to detain her in custody was fulfilled. That's to say that there was as it were, reasonable suspicion of guilt. And since the wording of the subsection under which he acted is may arrest without warrant, this left him with an executive discretion whether to arrest or not. Since this is an executive discretion expressly conferred by statute upon a public officer, the constable making the arrest, the lawfulness of the way in which he's exercised in a particular case cannot be questioned in any court of law except on the principles laid down in the Wednesbury case that have become too familiar to call for repetitious citation. It's quite interesting to put it in a, as it were, negative way, cannot be questioned unless, rather than as it were, positively. And then he says the Wednesbury principles, they're usually referred to, applicable to determine the lawfulness of the exercise of statutory discretion of a constable under Section 2 for the Criminal Law Act 1967, not only in proceedings for judicial review, all of which we would accept, but also, and this is the sting in the tail of the dictum, for the purpose of founding a cause of action at common law for damages for that species of trespass of the person known as false imprisonment for which the action in this instant case is brought. The first of those principles, the discretion must be exercised in good faith. That was established here. So, he continues, his exercise of that power by arresting Mrs. Holgate Mohammed was lawful unless it can be shown to have been unreasonable under Wednesbury principles, of which the principle germane to the instant case is the exercise of discretion must exclude from consideration matters which are irrelevant to what he has to consider. Now, what we say, first of all, this was obiter, because there was no debate about because it was not determinative of the case, which was decided in favour of the Chief Constable. Secondly, that the point was never actually argued either before the House of Lords or indeed in the Court of Appeal. We've set out the relevant extracts in our printed case at 9.3 and 9.4. We didn't actually have put in the sufficiently overburdened volumes of authority of the Court of Appeal case, but we do have it here just for completeness, so that your lordships and my lady will not think that we've been guilty of misquotation. This is what is dare say. Sir John Arnold said that the issue about reasonableness of the exercise of power in the last passage of that citation, that is not a matter which has been argued before us. It has been disposed of by assertion and acceptance. And the same is also the case in relation to the House of Lords. If one looks at the way in which the claimant's argument was described, one sees again that there's an absence of any reference to other than a submission based on Dallison and Caffrey. So, my lords and my lady, what we say emerges then are three main issues. Firstly, what did Lord Diplock mean? Secondly, if he did mean what the appellants say he meant, should his dictum be followed? And if it should not be followed, what is the principled basis for denying the appellants the remedy of damages which they seek? So I'll deal, if I may, and again, as swiftly as I can by reference to the printed case. The first question is, can one, as it were, read Lord Diplock's dictum down in any particular way? And there have been three ways, actually, in which the courts have sought to do this. One detects, as it were, a degree of discomfort in subsequent judicial decisions about the full reach of the dictum literally read. One interpretation is that what Lord Diplock had in mind was only whether or not it was lawful in the exercise of that discretion to detain someone, not to take them immediately to court, but while they were detained, to explore whether or not the reasonable suspicion upon which the arrest was founded was or was not made out. And again, one sees from the citations that we made in the same paragraphs of our printed case at 9.3 and 9.4, that was what was effectively in issue. It was the Dallison and Caffrey point, and in our submission, nothing other than that. And the courts in Australia have seized upon that, recognising what was indeed the issue that was before the House of Lords, to interpret the dictum of Lord Diplock as being restricted to that particular position. In other words, restricted to the proposition that it was in fact lawful in an exercise of discretion to investigate further before taking the detainee before a court whether or not the reasonable suspicion that animated the arrest was justified or not. And we've referred in our printed case to two cases of high authority, at any rate in their own jurisdictions, and of course in modern view, obviously regarded with respect elsewhere across the common law world. The first is the High Court of Australia in the Williams case. And you will see from lengthy citations, and I hope that it's not necessary to do more than refer my lord and my lady to those set out at 9.13 through to 9.17 of our printed case at paragraphs 53 to 55.
I'm sorry to be a bit thick on this, but why is this relevant to the particular issue we have?
Well, it's relevant to see whether there is any basis for confining first of all, to see whether one can confine what he said, and if what he meant was no more than such and such, and that isn't satisfied in this case, then that would be a reason, as it were, for not following it. I quite appreciate that my lords and my lady might say, well, actually, it doesn't matter what he said. What matters is what we think about the principles. Yeah. And I'm going to try, if I may, to deal with this aspect of it very shortly.
But this shows what the ratio is.
Yes.
But it doesn't help me, at any rate, on whether the dictum is right.
No, but what I'm saying with respect is that, I see what your lordship is saying. Your lordship is saying, in a sense, well, this is no more than relegating that to the margin of being dictum, and therefore we don't need to follow it. But as we construe what was said at some length by the various justices of the High Court in Australia, that's what, as it were, they assumed Lord Diplock had in mind. And I understand the way my lord puts it. The same point we're making in respect to the New Zealand case of Kira, which we referred to at 9.919 and page 55. Again, that's the way in which they said that's all that's being decided. Yeah. So maybe it goes no further than saying it's dictum. Let me put it at least this way. They don't show, as it were, any enthusiasm, saying, additionally, he said this, and that at least we agree with, if I can put it negatively in that way, as it were, yes.
The passages that you want us to look at are all quoted in your case.
They're all quoted in our case, and I
pages 53 to 55.
At this stage of the proceedings, ask your lordships to wearisomely go through the passages themselves. What it does perhaps show, again, is that not only was it, as it were, a dictum, but Lord Diplock may not, as it were, would not have been necessarily engaged with that issue at all, and that's the way in which other courts have. Again, taking this very shortly, and I entirely respect what my Lord Collins has said, second way in which it's been read down, if it goes beyond what I call a pure endorsement of the Dallison and Caffrey point, it's been restricted in the view of some, interpreted to say either there's bad faith or there are irrelevant considerations that go no further than that. We refer at 9.22 to an academic commentary, the only elaborated commentary on Holgate Mohammed that we've been able to identify. All I will say is that the academics, in construing Lord Diplock as restricting himself to bad faith and irrelevant considerations and going no further through the Wensbury canon, did so with a degree of regret, because their view was that actually he should have endorsed the full Wensbury canon. In other words, they wished to enlarge the circumstances in which false imprisonment damages could be obtained, rather than to narrow them. But that was the view that they took in that particular case. And again,
you can't get much wider than taking account of irrelevant considerations. And after all, that's, I thought, what we had here.
Well, or failure to take account of.
Well, quite, but I mean, why does that analysis help you?
Well, at the moment, if I may, I'm setting the scene here. It rather depends, again, what one considers to be here a relevant consideration or an irrelevant consideration.
I mean, as I understand Mr. Hussain says, well, actually, you don't need Holgate Mohammed. It's just absolutely a received truth post Annis Minnick. If it's ex hypothesi public law unlawful, that means there wasn't the power.
That's why I said he can bypass Holgate Mohammed and simply say it's entirely.
What's the answer to that?
Well, I'm coming to that.
Oh, all right.
I hope I'm coming to it. I seek to provide an answer. And just to conform, we've dealt with, as it were, the second way of restricting what was meant at pages 56 of our printed case 9.23 and 9.24, again showing that there has been a reading down in this and other jurisdictions. And then the third category, which we've dealt with between 9.28 and 9.38, pages 57 to page 60, there have been a number of cases in which it's been said, this will be very rare that this challenge on this ground could succeed, and matters will likely to be very limited, etc., etc. And again, I'm not going to trouble your lordships with what is fully set out in the printed case. What we say, by way of conclusion, at page 61, paragraph 9.40, what we say is it is clear that in addition to the English cases on immigration detention, of which the appellants form part, other English courts have been reluctant to apply a rigorous reading of the dicta in Holgate Mohammed, even in the context of short-term detention following arrest by the police. That reluctantly reflecting decision in New Zealand, which consider the Holgate Mohammed point, in the context of the actual issue in Holgate Mohammed to which the dicta were not relevant, and because the question to which the dicta were directed was not argued in that case, there's no need to follow those dicta when the unattractive consequences of a rigorous reading of those dicta rightly led courts to be reluctant to apply them. So the second section, before I, as it were, meet the point that my Lord Brown indicates rightly that I have to meet head on, is just to ask the question, if it meant what it said, should it be...
Sorry, Mr.
Yes.
Do any of these cases actually discuss the very sentence which is causing the problem?
No, I think they are just simply, as it were, saying this is all the case decides and no more, and reading it down in various ways to the extent it decides that it must be looked at in a very confined way. So the second issue is, of course, should the dictum, if followed, be given its full reach? And there are a number of reasons which, in our respectful submission, should lead this court to seek to depart from the full rigour of the dictum. Whether it's able to do so or not will be, as it were, the third head of submission that I shall seek to develop. And there are the number of reasons that we respectfully submit are relevant. I mean, the first is that it obviously erodes the distinction between the circumstance of the absence of any power or the non-fulfillment of a condition present or subsequent, and simply, as it were, another form of misexercise of the power. Now, of course, Annis Minnick have eroded those distinctions, but before Annis Minnick, those of us who studied law in those days will recollect that those distinctions did exist, and it's not impossible, as it were, intellectually to say there is a difference. Up to Annie's Minute, in terms of public law, that was indeed recognised. And if you go to Annie's Minute, and I'm not going to, it's so well known, if you look at Lord Reed's famous speech at page 171 of the Law Report, you can see he starts off by saying there is these circumstances where the tribunal has no power at all, and then there are the other circumstances which has power and it's vitiated, and we're going to treat them all together for future purposes. But that he recognised that the starting point was that there was a difference. Is not, in our respectful submission, capable of being disputed. The second point is that no distinction is in any event made between serious and less serious flaws in the exercise of admittedly existing power.
Could you say that again? I didn't quite catch
your
your words.
It makes no distinction, as it were, between serious and less serious flaws in the exercise of an admittedly existing power. I'm assuming, of course, that they are public law flaws, but they could be from minor to major. Thirdly, that it allows all the procedural safeguards which are inherent to judicial review, which is the conventional forum in which public law errors can be remedied, to be circumvented, time limits and the like, which is one, of course, of the reasons why Lord Liplock in the O'Reilly and Matman tried, as it were, to limit circumstances in which one could bring actions other than in that sphere when public law errors were at issue.
If you're going to say it erodes them, are they important? I mean, does it matter? I can see a public law point for time limits, but once you reach the stage that somebody's right to liberty, shall I say, has been infringed, and you're talking about his position as an individual, does the time limit point really matter?
But again, in a sense, one's assuming here, I mean, that the court would be sympathetic to the argument that one has to see some kind of potent connection between that which was alleged to be wrongfully done and the consequence of that of the detention. And all I'm saying is one of the matters in the judicial review sphere is the court is allowed to make this kind of distinction, and obviously perhaps the next point perhaps meets my Lord's question a little more directly. The discretionary nature of judicial review remedies, which is the core of public law, are simply ignored in the analysis obviously favoured by the appellants. And it is not impossible that one could envisage a situation in which a judicial review court might find that there's been a public law error in a decision to detain and would refuse all relief in the exercise of discretion, but on the appellant's argument, nonetheless, a claim for damages for false imprisonment could still succeed. We deal with that hypothesis at paragraph 7.11 of our printed case, if your lordships and my lady will be good enough to return to that. What we say is, the appellant's argument could lead to an action for damages for false imprisonment, even if the Judicial Review Court would have refused substantive relief. Indeed, at its strictest, the appellant's argument could lead to such an action, with full damages the entire period of detention, even if an unsuccessful judicial review application had in fact been brought. Given the procedural safeguards and the significant discretionary nature of judicial review remedies, it's entirely possible the Judicial Review Court might find there had been sub-public law error in the decision to retain, but refuse all relief, and yet the appellant's argument would lead to the consequence that the finding of some public law error entirely vitiates the authority to detain the individual, so that his action for false imprisonment must inevitably succeed, even though the Judicial Review Court had declined to quash the decision to detain. Now, at one stage, my learned friend, in the course of argument, appeared to accept that he was concerned only, as it were, with serious public law errors as distinct from trivial public law errors. But in our submission, once one opens the door at all, it's difficult to see where the line is to be drawn. My Lord Sir John Dyson, in discussion with my learned friend at that juncture, pointed out that, of course, the judicial review, the administrative court, is well familiar with drawing these particular distinctions in the exercise of its discretion. The administrative court would ask, what is the error here? What is its impact? And what relief, if any, are we going to give in consequence? But that, in a sense, is precisely our point. My learned friend's argument simply collapses all those issues and simply says, there is this error, and I'm going to be entitled to damages in consequence. I mean, suppose, and again, each side perhaps necessarily exaggerates the other side's case to a point of caricature, but just testing it in this way. Supposing the Secretary of State published a policy to detain designated deportees who had committed serious crimes, but only those with red hair. Such a person, I won't call him W, well, let's call him X, who is a designated deportee who had committed a serious crime, but had red hair, was detained under that policy. Now, if my learned friend is right, he'd be entitled to damages for wrongful detention when what was an indisputable classic example of a public law error was an attack, because it was both irrational and indeed discriminatory condition, which limited the class of detainees, when actually what one needs to strike down with a blue pencil that condition, which would allow, obviously, for the lawful detention pursuant to what was the underlying policy that those who committed serious crimes should be detained. And one can multiply examples of that kind in asking the question, well, just how far does my learned friend's case go? To what extent does there have to be some connection, and if so, what, between the decision to detain and the unlawful policy?
In order to bring your action for damages, do you have to set aside the decision?
Well, I'm going to come to that as a possible, that's one of the, what I call the possible solutions I'm going to come to in a not too distant future. Can I
have a one-word answer or not?
We would say that's a solution that you ought to, in fact, have to quash the decision, and if you do, then there is the possibility of play for discretion, and we'll show your lordship authority for that proposition.
Isn't the court used to dealing with these sort of problems? I mean, it's well established that a public law challenge can be invoked in private proceedings by way of defence.
Yes.
The Winder case, for instance.
Absolutely.
Well,
this isn't a... sorry.
Well, I know this is a claim rather than a defence, but all the points you've been making surely apply equally there, wouldn't they?
Well, yes, but my lord, the reason that in cases like Wandsworth and Winder and Boddington a fortiori, the court took the view that they couldn't sensibly ask someone who was the object of an adverse civil decision in Wandsworth and Winder, or a fortiori was facing a criminal charge, to be obliged to actually seek to establish the invalidity by separate action. I mean, that would not be obviously consonant with the views of justice, and therefore they took, in our respectful submission, a pragmatic view that if you were a defendant in either of those two categories, you shouldn't have to do that. But non sequitur, that if you're a claimant, you aren't going to be under the ordinary obligation to establish, as it were, in a court vested with discretion, that there has been some error of that kind.
Yes,
That's the way
it only occurred
distinguish
to me
it.
because there's no suggestion in those cases involving defendants that they should first go to the administrative court, because they'd almost certainly be out of time.
Well, I entirely accept that, but one can immediately see the policy of justice, as it were, in saying, in that category of case, you can't make that requirement. I mean, that is why, in a sense, O'Reilly and Macman has been, as it were, eroded almost from day one, and that was perhaps the first of the obvious erosions. Can I just give one other example, again extravagant, but again perhaps it illuminates what we say is the problem in my learned friend's argument.
Before you do that, sorry. The example you've given is an extremely interesting one, because it immediately makes one think of the Belmarsh case, where a particular group were singled out for executive detention irrationally, as the House of Lords found. Of course, there had to be a declaration of incompatibility, but it did actually make that detention unlawful, not in English law, but in accordance with the Convention. The fact that, of course, if it had been properly done and everybody had been included, it might have been okay, there's neither here nor there.
But it couldn't have properly been done, because to distinguish, as it were, to put British citizens, persons not subject to immigration control, under detention for the same reason, there was no statutory basis for so doing.
I'm not talking about the statutory basis, because, of course, we were looking at the validity of the statute.
Yes.
But just thinking through that particular situation, the fact that you had singled out some people for adverse treatment on a discriminatory basis, when you might, on certain hypotheses, have been able to apply it to everybody, didn't make it any less unlawful to give them that adverse treatment. It's just an example.
Yes, but my lady, in that circumstance, there was no possibility of equal treatment in that sense, because they would never have been able to say, as it were, it's an equality of misery or an equality of detention or something of that kind.
Well,
it simply wasn't.
With respect, they could have done, because they could have derogated from the Convention and legislated to do the same to everybody. And then we would have had a different sort of argument on our hands.
Well, first of all,
more or less what they did.
But to achieve a situation in which British nationals could also be detained in those circumstances, well, there would have to be several steps, as it were: derogation of the Convention, the imposition of national legislation, which itself might have been highly controversial. Those are, as it were, it's not here, as it were, one's in the territory where the difference between what was done and what could have been done is in a very narrow ambit. It was perfectly possible, indeed, the underlying policy was that persons in the position of these two appellants should have been detained, whatever was the policy, whether it was published, unpublished, presumption one way or another. It simply isn't in the same, as it were, area as the example
the problem, my lady, identifies with your
to me.
red hair example is that you put it forward as red hair being one of the mandatory requirements.
Yeah.
Whereas if you had said the following considerations can be taken into account, A, B, C, D, E, and F was red hair, your argument would be, well, the fact that you've included red hair in the bundle doesn't matter if you would have reached exactly the same conclusion absent the red hair.
Yes, well, that is
under
it.
the statute.
That is it, and of course, shall we take an even more extravagant example? I mean, Lord Roger put to me, quite properly, was I right in saying it's only a policy unpublished that is less favourable to a detainee than the published one that could conceivably attract a remedy of judicial review? And we've been thinking, my immediate reaction was, where would the locus standi be for a general member of the public to take such proceedings? So we conceived of a situation in which the locus standi problem is overcome. Published policy says that ex-foreign national prisoners or foreign national ex-prisoners convicted of serious offences will presumptively be detained, subject, of course, to special circumstances, which would have to be because blanket policies aren't allowed at all. A secret policy, however, says they will be released after 9 months. Detainee who is released under the secret policy commits a crime of violence. The victim of violence, discovering that the existence of the secret policy, we inevitably have locus standi to bring a challenge because obviously it's been affected, the secret policy is declared to have been unlawful and is quashed. Now, on the appellant's analysis, as we would understand it, the detainee would be able to claim damages even for the 9 months detention on the basis that he was detained where there was an unlawful policy in place in relation to detention. And again, in our respectful submission, that cannot be right. There must be some kind of connection or link. I'm going to almost eschew the word cause because I think it may be confusing in this area, the vocabulary of causation, materiality, and so on and so forth. Really, I prefer to look the other way around. What difference did it make? Now, can I then come to the Annie's Minute point, because my Lord Brown quite properly said that's really, and indeed all my lords and my lady have in effect indicated that may be the real issue here. Now, what we say about Annie's Minute is this. It obviously solved one set of problems in public law by amalgamating a total absence of jurisdictional power with a misuse of jurisdictional power under the general rubric of ultra vires. But what it has, in our respect for submission, clearly left unresolved are the problems that are consequent on classifying acts or decisions flawed on any such ground across the whole range as being nullities, and in particular as to the impact on actions that have been taken on the basis of what were previously presumed to be valid acts or decisions before the court has formed a view and expressed a view that they were invalid. And we've cited at paragraph 7.19 and 7.20 at pages 39 and 40 two extracts from the Boddington case itself. Because although, of course, in that particular case, for reasons that I sought to advance in response to the question from my Lord Sir John Dyson as to why it was that no requirement was imposed upon the defendant in that case to seek a quashing order of the bylaw, that justice obviously did not require, indeed contradicted any such approach by the court. Nonetheless, both Lord Brown-Wilkinson and Lord Slynn did say we are not to be taken as saying, as a result of our finding in this case, that every time there's been something a court holds to be invalid, necessarily everything is to be treated as if it hadn't properly occurred at all. And what Lord Brown-Wilkinson said, he referred to Lord Irwin's speech, and again, classically saying an invalid act is and always been a nullity. The bylaw will necessarily have been found to be ultra vires, therefore it's said to have a nullity having no legal effect. I adhere to my view, the juristic basis of judicial view is the doctrine of ultra vires, but I am far from satisfied that an ultra vires act is incapable of having any legal consequence during the period between the doing of that act and the recognition of its invalidity by the court. During that period, the people will have regulated their lives on the basis the act is valid. The subsequent recognition of its invalidity cannot rewrite history as to all other matters done in the meantime in reliance on its validity. The status of an unlawful act during the period before it's quashed is a matter of great contention and difficulty. And Lord Slynn, perhaps I can just simply refer to the first 4 lines. My lord and my lady could read it if they choose to at their leisure afterwards. I consider the result of allowing collateral challenge in proceedings before courts of criminal jurisdiction can be reached without it being necessary in this case to say that if an act or bylaw, and I do stress the words that it was not just concerned with bylaws, although the case was, the dicta are clearly more generous in their ambit, it must be held to have been invalid from the outset for all purposes, and that no lawful consequences can flow from it. This may be the logical result, and will no doubt sometimes be the position, but the courts have had to grapple with the problem of reconciling the logical result with the reality that much may have been done on the basis that an administrative act or bylaw was valid, and the unscrambling may produce more serious difficulties, etc. And he goes on to say the European Court of Justice has certain ways of confronting this problem, and then he refers to the academic debate in Wade and Forsyth at that stage in its 7th, 9th, its 10th edition, lead the author to the view that nullity is relative rather than absolute concept. The law is void and meaningless in any absolute sense. Its meaning is relative. This may be all rather imprecise, but the law in this area has developed in a pragmatic way, case-by-case basis. And what we respectfully submit is that our search for what we say is a fair solution to the particular facts of this case does not necessarily shake the very pillars of public law. It's been recognised by high authority that there are a series of problems that have not yet been resolved. Cooper and Wandsworth, my Lord Hope, asked me to respond to Mr. Singh's and Ravinder Singh's submissions based on this. And he, as he rightly says, it's an ordinary action for trespass. The house is demolished without the opportunity being accorded to its owner to be heard. The court classically implied into the statutory provision the right to be heard in advance of the demolition. And of course, I'm not questioning the decision in Cooper and Wandsworth. It has stood for over a century and a half, been frequently cited. But of course, there the public law flaw was what made the demolition unlawful. There was a direct and clear connection between the two. What one doesn't, of course, know in that case, supposing the local authority had said, supposing we had heard you, it would have made no difference at all. We haven't, in that case, the slightest idea whether that would have been a solution or otherwise.
Well, it couldn't have been, because the basis of that decision, as I'm just looking at it now, is that the board had not qualified themselves for the exercise of their power because they hadn't heard. And therefore they had no power to do
it at all. Well, I mean, we simply say it's not in para materia again. We simply aren't confronted there with as it were, a response that the board could have made, saying, we would have done this in any event quite lawfully. So, all we say is, in a sense, that Cooper and Wandsworth simply identifies the problem that we have in this case. Now, again, there has been, not only has there been high judicial comment on the problems created by giving full effect to the anisminic doctrine and treating everything which is flawed by public law error as being a nullity for all purposes, there have been a series of attempted solutions, and neither of which are in fact germane to this particular case, so I deal with them quite shortly, but only to show that there have been efforts to bypass the strictness of the anisminic analysis. One we refer to is Professor Sir William Wade and Christopher Forsyth in the 10th edition of Administrative Law. We refer to that at 7.14, page 242. The second conundrum is that the Act may be clearly void, but the court may be unwilling to grant the necessary legal remedies. The invalid Act, being beyond legal challenge, becomes effectively valid. Now, when I reread that, it occurred to me that Your Lordship, my lady, had not been given the opportunity to see that observation in context. And can I, without, as it were, going further down that path, simply have handed to the court the chapter in which that observation in fact appears, because the extract in the authorities bundle is incomplete. Have you got one copy for me? All I need to do for present purposes is to identify that the passage that we quoted at page 252 comes in the context of a learned discussion of the problems facing the courts if they apply the view once a nullity, and always a nullity for all purposes. The second solution that has been essayed judicially is the so-called second actor case, the solution. That's, of course, where someone says, it may be that higher up the line you've made an error, but I've acted in good faith on the basis that what you told me to do was in fact authorised, and therefore I ought to be immune from certainly any tortious claim. Now again, that doesn't work in this particular case because the challenge is to the Secretary of State, not, for example, to the relevant person in charge of the detention centre. But again, we've referred to the somewhat complex saga of Percy and Hall, which effectively, as it were, backwards and forwards, a decision was finally reached that a bylaw applicable to Greenham Common, to certainly, or another military base, at any rate, a military base, protesters ultimately decided that the bylaw was in fact invalid, and the decision was taken that nonetheless the police who acted on the basis of its validity were not themselves to be subject to a claim for damages for false imprisonment. And we've set out the history of that matter at pages 37 through to 39 of our printed case, 7.12 to 7.17. And all we say is it's not germane here, but it does show that the courts have been concerned and have sought to qualify in appropriate cases for no doubt good and sufficient policy reasons, as it were, the full rigour of Annie's Minute. So I come, as it were, to potential solutions.
Another context is it not the decision of the Court of Appeal in Cart in relation to...
You're coming.
Yes.
I'm glad to see that my Lord's ahead of me, as always, but I'm going down slowly the same track. Can I just hand in another piece of paper? But luckily it's a single sheet, and again it's just a route map, just to show what we say are potential solutions to this problem. Give me one as well.
Are these the same as your alternative ways forward, starting at page 62 of your case, or is that?
Yes, they are.
Yeah.
They are. But I've actually slightly reordered them because I thought the order that we've got here is more logical. But what as Mr. John Jarvis says, it's absolutely so. And what we've done, as it were, to make it easy, is to put in the references where the argument is developed in our printed case. And we've really got 7 possible alternatives. The first, obviously, is the causation, as I'll call it in quotation marks, issue. The second is that false imprisonment should be restricted to a complete absence of authority. The third is authority detained should be vitiated by pre-and error of law only. Fourthly, authority detained vitiated only by bad faith or improper purpose. Fifthly, authority detained vitiated only by failure to have regard to material consideration which had effect on the detention. Sixthly, the requirement for the court in the exercise of discretion to quash a decision to detain as a sine qua non of an award of damages for false imprisonment. And seventhly and lastly, causation at any rate, if not an ingredient of false imprisonment itself, an ingredient of an award of more than nominal damages. So it's something, if I may say, of an a la carte menu. And what we're hoping is at least one dish will prove its taste. And obviously there is a considerable measure of overlap. I mean, one sense, absence of power and error going to fundamental jurisdiction and its minute terms are very closely related. Exercise vitiated by bad faith or improper purpose is very close to absence of power, because one can hardly attribute to an intelligent legislature a view that powers can be exercised in bad faith or improper purposes, and then a strict view of relevance and the need for causation for either for tort or for the remedy, again, are closely allied. They're different routes to a single destination. Now, what's been attractive below, as it were, the plat du jour, I suppose, to pursue the metaphor, has been the causation issue. That was the root of what was obviously thought to be a disagreeable conclusion in fact or indeed in law, favoured by Mr. Justice Davis and by the Court of Appeal, and we deal with that in our printed case at paragraphs 8.1 to 8.22 from page 42 and following. The Court of Appeals paragraphs, just for my lords and my ladies' note, they are paragraphs 80 to 90 at pages in the first volume of the Weekly Law Reports of this year, 2,200 to 2,203. Can I make two prefatory remarks? First of all, we don't actually accept that the argument is properly classified as somewhere as a raising of a causation defence. We would rather see it classified as a necessary ingredient of the claim in the first place. And the second prefatory remark is at least there is this measure of common ground between the appellants and the respondents, that the unlawful policy must have, as they say, influenced the decision to detain. In other words, it was taken into account. They say that in paragraph 30. So that unless, in point of fact, one could show some link between the policy and the detention of the detainee, he would have no claim for compensation arising out of unlawfulness.
So, did I understand you when you spoke at an earlier stage, during the time when Mr. Same was speaking, that you accepted, I'm just trying to clear what the facts were, the unpublished policy was applied to these appellants? That's what I understood you to say.
It was applied to these appellants.
So what does that mean in this context?
Well, what it means is that those who were vested with the department vested with the power to detain considered the underlying policy, that's to say we want to detain persons who've been convicted of serious crimes. They did it, however, in the context of a policy that was vitiated or flawed in the way which I've indicated and conceded.
But there's an ambiguity, isn't there, in your proposition?
Yes.
Where you say the unlawful policy must have influenced the decision.
Yes.
It could mean subjectively it was that policy which the decision maker had exclusively in mind, didn't even bother to consider what his answer would have been if that policy hadn't been in place.
Yes.
Or you can say that it only influenced the decision if the same decision wouldn't have been taken absent.
Well, it's really the second, obviously, of the two, the way I'm putting it. I mean, in one way, if someone had said to the Secretary of State or the relevant official, by what authority are you detaining these two appellants and why are they still detained? They would have said, we're exercising the powers that the Secretary of State has under Schedule 3, Paragraph 2 of the Act. And that would have been, in that sense, sufficient as a description of what they were doing. And in that critical sense, we say the policy did not cause or influence, use my Lord President, the detention.
I'm sorry, I too am a bit sort of concerned about this. I mean, the blanket policy that you accept was unlawful. This was from the November 07, from Cullen 1, which, in fact, rather paradoxically, was a slight relaxation of the absolute blanket policy. But there it is, let's pretend it's a blanket policy. Now, if you're applying a blanket policy, then actually, surely, you're just looking, has this chap been convicted of one of these offences, if so out? And so he is not being considered except in that context. Does the blanket policy apply to him? Is that right?
Well, right up to the point where one then says, but actually it didn't matter because whether supposing he had been told by someone, a lawyer of high authority, you can't do this under this policy, it's undifferentiated, it's unpublished and so on. What would he have said? Would he have said, I can't do it at all? No, he'd said, well, so be it. but I'm perfectly entitled to detain him because he fits these particular criteria. That's really what this case is all about, how you see the question of the influence or the potency of the link between the flawed policy and the decision.
But
given that advice was not conveyed to the Secretary of State, how can it be said that the policy which governed these decisions did not influence these particular decisions?
Well, my Lord Lord-Care, I mean, I accept that it influenced them. If one means by influence, does this mean that that the result could only flow from the application of the policy? The answer is no.
Well, influence to me, I think, as its synonym, played a part in arriving at the decision. Did it play a part in arriving at the decision?
Well, yes, I can't dispute that it played that part. I'm not saying that people were ignoring the policy. They clearly were not ignoring the policy. But the real question surely is, was it critical in their decision to detain? In other words, was it something that was an add-on? And if they'd been told, you can't do it like this, they would say, well, that's fine. Right? We'll go back to the published policy and accept that we have that there must be an obligation to consider each individual case. On these particular cases...
Well, Mr. Beloff, I entirely understand the way you're putting it, yes. But I don't believe it's common ground that your proposition is right. I understood it. What was common ground is that the decision maker must have been influenced by the unlawful policy. And if he was unaware of it or was simply put it out of his mind and applied the patent policy, then it would be an irrelevance.
Yes. You know, I'm not trying to suggest that Mr. Hussain has walked into some kind of forensic trap. I entirely accept all he was saying was very sensibly that if you had an unlawful policy, but it was never going to be in the mind of anyone taking the decision, it wouldn't be sufficient. There would be an entire disconnect. The battleground is what's the degree of connection required? Is it sufficient just to say, as my Lord Care puts me, and I hope I answer candidly and clearly, yes, obviously the person committing the detention had in mind that particular policy that we were asked to do. But whether that's sufficient in circumstances where, had they been told that aspect of the policy is unlawful because it's unindividuated, because it's contrary to published policy, and they say, well, so be it. I'll follow the published policy and I will reach exactly the same decision. That's, in a sense, what you should be hearing, ladies, you've been hearing arguments about 4 days. In the end, it comes down to one's perception of that, of which analysis one does, in fact, follow.
Can we just go to burden of proof?
Yes.
The claimant proves that what motivated the decision maker was the unlawful policy.
Yes.
Does he have to go on to prove, and furthermore, if he'd applied the lawful policy, he would have reached a different decision?
No.
Or do you have to?
I think that's something we have to do.
Yes.
I think that must be right. Yes. Yes. That must be right in principle.
Well, that makes it a defence, in effect, doesn't it?
At that stage, it would make it a defence.
Which is contrary to what you said that I wrote down a few sentences ago.
Yes, but when one says, I mean, the ingredients of a claim, if one talks it in pleading terms, at the end of the day, the question of whom the burden of proof lies is not the same as what are the ingredients of the claim. It's a pleading point. At the end of the day, one has to decide whether, in fact, then, to the extent that I'm going to use the ambiguous and elastic word influence, at the end of the day, whether it's the Secretary of State prove it didn't influence or did, at the end of the day, the decision will be whether or not that's been made out, irrespective of the fact that it's the Secretary of State at that juncture, as I respond to my Lord the President.
Perhaps I'm advancing a little bit, but looking down your list of potential solutions, number 7, of course, is the damages solution. It's a damages solution, but where does the burden of proof lie there? I mean, if you get to the point where there is an established cause of action, a private law cause of action, and there's a claim for damages.
There, I would say, it's the person who says, I've actually suffered damage from this to establish it.
Well, he would say, he would raise a case, he said, I've been detained for X months or years under this policy, this unlawful policy which was applied to me.
Yes.
And surely the burden would then pass to the respondent to say, well, that may appear to be the position, but actually you haven't suffered any substantial damages because on this analysis, because if I'd applied the correct policy, the answer would have been the same.
Yes, that may be right. In this particular case,
It seemed to be right. I mean, you're in the best position to know.
Perhaps it would be inconsistent with my previous position that one has to establish it as a defendant or respondent in relation to the substantive tort, and the same would apply in relation to the damage.
Right.
I think that a coherent analysis must be of that character. Can we just then look, I mean, my own friend, as it were, parked, as it were, the issue as whether Sadi was in some way inconsistent with the Christian Leszczynski. We actually say there's no tension between the two. Christian Leszczynski was, as it were, a condition precedent case. Sadi was reviewed as simply a misuse of executive power, and yet the misuse, which was finally the one that commented on by Lord Slid in the House of Lords, was not held to result in the fact that the decision should be avoided. Bearing in mind, of course, that Sadi started off not only as a claim for declaratory and other relief, but actually did start off as it were, a putative claim for damage. I mean, Mr. Justice Collins referred to it as being a prequel to a possible claim for damages. Can we just look again? I'm very conscious of the time. I'm conscious of the fact my lords and my lady have seen this before, but I'd just like to go to, if I may, both that case, Naraja and the Home Office. I've already dealt with Langley, I hope, preemptively, and then finally Annam, which I think one needs to look at because there appear to have been some possible misapprehension about what the approach of the Court of Appeal in that particular case was. So if we can go just first then to Sadi, and I'm going to say, if I may, as it were, introduce these cases before one gets to Annam, is to say that these are three cases in which we respectfully submit on proper analysis, as it were, causation or linkage issue was in the forefront both of the decision and the analysis, and it was because of, as it were, a lack of connection between what was seen to be, or rather a presence of connection in some cases, a lack of connection in others, that different results were in fact achieved. So Sadi is in the House of Lords at volume 11 at 119. We're starting at 11, yes. The House of Lords is at 120. Can I just remind you, since Mr. Hussain very helpfully took my lords through the legal history or procedural history of this particular matter, it was all about, as it were, the presumptive detention in the Oakington facility. There were two challenges made before Mr. Justice Collins. One was that it was inconsistent with the statutory purpose of individuation, and secondly, that it was a breach of Article 51F of the Convention because it was not necessary. He rejected the argument and in relation to the domestic statutory interpretation. He accepted relation to the Convention. He referred to the fact that inaccurate reasons were given as a disgrace at paragraph 16. When the matter went before my Lord the President, presiding at that stage in the Court of Appeal, the Court of Appeal actually endorsed Mr. Justice Collins on domestic statutory construction, reversed him on the Convention grounds, appreciating obviously properly, the limits that Chahal had made in respect of imposing conditions on detention with a view to deportation. Remarks were made that to the extent that the unpublished policy was, to the extent that the policy was in conflict with established principles of public law, it would have been vulnerable to being quashed. But in fact, by the time the Court of Appeal was seized of the matter, a public policy had been announced so that no further issue was taken there. And then in the House of Lords, again, the substantive appeals on both grounds, both the convention ground and the domestic ground, were denied. It's the next tab, yes. It's the last or the penultimate one, it's 120. At 48, Lord Slynn then came back to the issue of the service of improper reasons, inaccurate and therefore improper reasons. And what he said was, with the concurrence of the other members of the House, it's agreed the forms served on the claimants were here inappropriate, to say the least unfortunate, but without going as far as Mr. Justice Collins, the criticism of the service, I agree with him that even on his approach, the failure to give the right reason for detention and the giving of no or wrong reasons did not in the end affect the legality of the detention. So he was accepting, as it were, if one approached it per Mr. Justice Collins, this was disgraceful, it was therefore be unlawful. He was saying, even then, that doesn't matter, because what I have to identify is a connection between the detention and the inaccurate and invalid reasons. And perhaps the use of the word affect is a verb that perhaps is less freighted with other meanings than the word cause. So that's what we say about that case. It's an example, as it were, of a what I'm loosely calling a causation disposition of a matter. We know, of course, then, that as we set out in our printed case, the matter went to the European Court of Human Rights. This has been recited on several occasions, and we deal with that at 8.6. It's obviously quite clear from the decision of the European Court of Human Rights that they were not concerned with the fact that though ordinarily it was an obligation under Article to inform persons properly and fairly and fully as to why they'd been arrested or detained. Nonetheless, they weren't going to hold that there'd been any violation of Article 5.1f in those circumstances, and it had no effect, accordingly, on the validity of the detention. Just for your note, we deal with that at 8.6 at paragraph 43 of our submission. Page 43. Then the next one is Narad Raja. My learned friend said, no, well, that shows if you've got an unlawful policy, that's effectively the end of the case. Can we look? That's 14, I hope at 137. I looked at that this morning. Now, again, this case has been much and usefully rehearsed, so I don't need to remind my lords and my lady of it. We're going. Paragraph 68 to 69 are, in fact, crucial. My learned friend emphasises the fact that in those circumstances, the fact that the relevant policy had not been made public was itself the reason why the detention did not satisfy the criteria of lawfulness. We say with respect that, like all observations, they have to be read in the context of what was being decided. And my Lord the President, as Master Rolls said, in the middle of page 161, in the middle of paragraph 68, this critical fact those acting for, yes, his solicitors, just a little line of, his solicitors had given notice to the Home Office and to the Immigration Service of his intention to seek judicial review. It's not been suggested by the Secretary of State there was any reason to doubt this intention was genuine and would be implemented. Those acting for N could reasonably expect, having regard to those aspects of the Secretary of State's policy be made public, N would not be detained on the ground that his removal was imminent. The only basis upon which the Immigration Service could treat his removal as imminent was by applying that aspect of the policy which had not been made public, namely that no regard would be paid to an intimation that judicial review proceedings would be instituted. The Secretary of State cannot rely on this aspect of his policy as rendering lawful that which is on the face of it at odds with his policy as made public. And for these reasons, we agree with Mr. Justice Stanley Burnton. And then reference is made to the remark that there was substance in Mr. Hussein's submission that N's detention was a penalty for his solicitors failed to initiate judicial review proceedings before the interview at which he was detained. That's perhaps irrelevant, but the next sentence is critical. The evidence suggests that had she been aware of the unpublished aspect of the Secretary of State's policy, N's solicitor would have instituted proceedings before the interview. N suffered because his solicitor could not foresee the consequence of her conduct. N's detention did not satisfy the requirement of lawfulness imposed by Article 5(1)(f). Now we say, accordingly, read in context, what one had here was an unpublished policy which actually effected the decision, because the published policy didn't bring home to the solicitor for N that she needed, as it were, to institute proceedings rather than to simply give intention so to do. So it was a legitimate expectation case created by the public policy, the unpublished policy inconsistent with it, that actually caused damage to N because of the way in which his or her solicitor properly acted, and in those circumstances, we say, using Lord Slynn's vocabulary, it did affect the legality of the decision. So we say it's cut from the same cloth as Sadi. In Brooke, the penultimate case in this sequence, that's tab 14, D in the Home Office, 141. It's the same volume, mercifully. This one can go straight, if one may, the Court of Appeal again at page 110. Page 1033. Paragraph 110, my Lord. I cannot have it. I hope this is right. It's 141.
Yes.
Yes, I'm obliged. Mr. Catchpole submitted we should bear in mind the consideration when the administrative court quashes the decision of immigration officer on the ground of public law error, there will be nothing to stop him making the same decision, this time by a lawful route. It appears to me the answer to this objection lies in the field of causation. He then analyses both Naraja Raja and Sadi as being causation cases, and we would respectfully submit that that is so. And interestingly, although, as Mr. Hussein rightly points out, Lord Justice Brooke then, in fact, regards, as it were, the anisminic category as a no-power case, whether or not there were no power at all, or failure to take account of material considerations, because you notice Mr. Catchpole advances the argument on behalf of the Home Office that there is a difference, and Lord Justice Brooke says, no, there's no difference. There's no power to authorise the detention in question. That's what the doctrine of ultra vires is all about. And then he referred to an earlier case which has been superseded. But we say with respect that his emphasis on the need for causation, effect, affectation, materiality, call it what you will, is all the more impressive in the context of a judgment which otherwise accepts the very argument that Mr. Hussein is advancing. So it's not made less impressive from the Home Office's point of view, but more impressive. Landau were dealt with in its common ground, I think by now, that the issue of damages was never raised in that case at all. So I need just to come to Anam, because it was the observations which were perhaps not fully appreciated, the way in which the court was there approaching it, at any rate in the context of the argument that now engages the Supreme Court. That is, I hope, 22 tab 224. Yeah. And I just wish to refer, my lords and my lady, to three matters. First is the leading judgment, although the Court of Appeal was unanimous, was given by Lady Justice Black. And at paragraph 17, she refers to, in the second sentence, 5 lines in, the submission advanced on behalf of the detained appellant. At its most radical, the submission advanced by Mr. MacDonald, the Queen's Counsel, Mr. Said for the appellant, is that a failure by the Secretary of State to apply his published policy in making a decision to detain necessarily renders that decision a nullity and the resulting detention unlawful. And then they go on to then say how they criticise Mr. Justice Cranson. And then this observation, not uninstructed by the Court of Appeal, in the event that existing authority in this court is found to preclude this radical submission and some sort of causation analysis is necessary, then an alternative argument is ventured. I simply draw attention to the fact that the Court of Appeal thought that this was a radical submission, and one infers from that that they were not wholly attracted by it if there were some way of avoiding it. One then goes on to paragraph 77. Because my learned friend read, as it were, only part of this, the impression may have been gained by the court that what Lady Justice Black was saying was that the Secretary of State had to establish, in the context of a causation analysis, the inevitability of the decision being taken in the same way, whatever policy had been applied. And again, 6 lines or 7 lines in, I am inclined to agree that if the court confines itself to a consideration of whether it was inevitable the decision would have been the same if the error had not been made, it's abdicating the responsibility it has as a primary decision maker in cases concerning liberty of the subject. It might have been argued by the appellant that the abdication produces a position which in fact favours the person who's been detained and is therefore at the very least entirely acceptable because it removes the usual acceptance of a band of reasonable decisions and requires the Secretary of State to surmount the ultimate hurdle of inevitability if the decision is not declared to be unlawful. In fact, this was not argued, and in any event, it seems to me that the inevitability hurdle introduces an undesirable degree of sophistication and technicality into what could be, and I think is essentially a simple proposition, the course itself prescribes the legality of detention, attaching appropriate weight in its deliberation to such matters as government policy risk assessment, evidence likeliness timescales for the deportation of the individual, and then she says it gives rise to the challenging question of how such approach fits alongside the rather different approach required of the court in applying Hardyall-Singh principles. And she says in her concluding passage, you ought to look at the cases, as it were, all as a unity and not bifurcate them into 2 different sections. But the impression may have been given, if one read only the passage referring to inevitability, that she was going to say that that was the hurdle that the Secretary of State had to meet. But if one goes on, one sees that she wasn't attracted by that, and clearly she thought that there would be a lesser hurdle in the path of the Secretary of State than the hurdle of inevitability. And so that was just to correct an impression that I felt from the dialogue might have been miscreated by an unfull reading of paragraph 77. And then finally, I just refer, third and last reference, to Lord Justice Maurice Kay. He refers to Harjil Singh, etc., etc., and he then refers 4 lines from the end of of paragraph 91 on the last page of the judgment. He refers to what various have described the materiality or causation approach. I'm bound to say if the question were free from the authority, I would favour the materiality approach. And so, again, somewhat diluting, as it were, strict causation. Just let's see how material, in fact, it is. And it comes not too far distant, his position, from the position we espouse. Finally, under this heading, I just deal with...
I'm sorry, just before you leave that one, I mean, what's the authority that binds him against materiality?
I think it's SK, my lord. It may be
it's
SK itself, which I think your lordships are in the process of deciding.
Paragraph 88.
Yeah, paragraph 88 is referred to. Yes, I'm much right. Can I just make 2 points? We do make, perhaps it's the last refuge of the forensic failure, an appeal to common sense at paragraph 8.21 of our written case. But may I nonetheless just invite the court to bear this in mind, page 47. Just taking it down, I mean, yes, as the Court of Appeal pointed out, such causation approach accords with legal principle and common sense. To take the example of R and D and the Home Secretary, page 47, 821, why should a detainee who's not received a medical examination within 24 hours required by the rules receive damages for unlawful detention, even if it be shown that he would have been detained anyway had the medical examination occurred within 24 hours? A failure to follow a detention policy may be regarded as a public law error. On an application for judicial review, the grant of a remedy would always be discretionary. If a public law error in relation to a detention decision were demonstrated by an individual, but the circumstances also show the error made no difference, if you've been detained even if there had been no legal error, it's likely that no relief or substantive relief would have been granted by the judicial review court, and even if substantive relief were granted, the decision maker might lawfully be able to reach the same decision again without committing any legal error. In circumstances in which such legal error could be seen not to have caused the detention, in the sense that it made no difference to whether or not the individual would have been detained, it would be anomalous if the detention must nonetheless be regarded as unlawful and carry with it a concomitant right to compensation. Yes. It should be, in fact, apparently Mr. Justice Davis, they should have, yes, the citation should start with a reference to, as Mr. Justice Davis, in the appellant's case, pointed out, not the Court of Appeal themselves. Now, two final points on this causation issue. Firstly, Mr. Hussain says these are at the serious end of public law clause. And I assume, for the sake of argument, that your lordships and my lady approach it on that basis. But we say that's not the issue. The issue is an influence issue. Did these errors, however serious, actually make a difference? Same issue, whether they were trivial or serious. Compensation is not to be awarded here on the basis of a public law error. That is, of course, contrary to a long line of decisions in this court and otherwise, that administrative error by itself gives no basis for judicial review. Obviously, if the error ventures...
Well, they don't normally result in people being locked up.
No, I understand that, my lady, but again, that comes back to the influence issue. If, of course, the errors are such that they amount to a misfeasance in public office, there is, of course, a tortious remedy. I mean, that's the way in which it goes in terms of compensation. Finally, Mr. Hussain raised a series of points about, is the Secretary of State able, for example, to say, albeit I detained wrongly, nonetheless, I could, under other entirely distinct powers, have detained these appellants? Or even could he say, There are other departments of state, or the, let us say, who got powers to detain, who would equally have been likely to detain. These extravagant caricatures of our case are simply unrelated to it. Our case is focused on a very narrow situation. We say that the fact that we're not relying on the fact that we could lawfully have exercised some other detention power altogether. We're not relying on the fact that some different detainer might have lawfully exercised detention powers. We're simply relying on the fact that in the exercise of this power, which undoubtedly we enjoyed, the detention in fact made no difference. We focus, in short, and invite the court to focus on what we did do and not on what someone else might have done. And that's why, with respect, the real issue, I mean, it's bedeviled, as I say, by issues of causation, as Lord Hoffman pointed out in Kuwait Airways. Causation has different connotations in different contexts. It's simpler for us to resort to the vernacular. Did the fact that this detention was ordered by reference to what we accept to be an unlawful policy have made in the real world any difference at all to the result? And we say with respect, no. Now, of course, it's necessary to make good my submission that actually the result would have been the same in any event. Now, we have set out at the start of our printed case the facts relating to the case of these two appellants. And I'm not going to read those in detail. I should, however, correct and apologise for an error that I made in my opening observations in suggesting that WL had been guilty not merely of offences of violence and of sex offences. He had not, and I want to make that clear, although others in the pack behind these lead cases actually had, which is where the error crept in.
So where is the error?
I'm so sorry.
And whereabouts in your printed case there?
I'm not certain it's in the printed case.
I see.
It was my oral submission.
Oh, I'm sorry. Okay.
The introduction to my oral submission.
Yeah.
And his offence was wounding with intent.
Wounding with
and that's all it is.
So on. Yes.
Serious enough, but that's
Yes.
it.
So, I mean, there's no doubt at all here. I mean, not only did both courts, and I hope I can take this quite shortly, not only did both courts below find it entirely clear that the decision to detain would have been the same, given the circumstances of the cases of these two. But actually, one has a series of illustrations. I mean, I'm just going to summarize. Firstly, WL, no doubt, a number of very serious offences, criminal offences, serious risk of reoffending, high risk to members of the public. Second point, those who have considered the merits of his detention and have concluded he should not be released from detention have done so actually in circumstances where they were applying the policy, the published policy, in favour of release. Mr. Justice Collins, in fact, did that on two occasions. On the 14th of May, Appendix Part 2, page 2199, and after the hearing on the 24th of July, see Core Volume 2 at page 139. You recollect, as Mr. Singh told you, at that juncture, there was, alas, uncertainty on behalf of those representing the Home Office as to what policy had or had not been applied. So Mr. Justice Collins, in those circumstances, said, well, I'm going to simply confine myself to the published policy, and to Hardil Singh, ask myself the question, should he be detained? The answer was yes. Thirdly, following Mr. Justice Davis's judgment, and in the light of his conclusion that a presumption in favour of release should be the benchmark, such a policy was introduced on the 22nd of January 2009, and there have been frequent revisitings by the officers of the Home Department as to whether or not there was any change in the position, and I think I've counted 8 or 9, and they have all decided that the decision to detain should remain in exactly the same position. As far as KL is concerned, not only does one have a series of offences, including robbery, drugs, etc., one has an actual example of an attempt to escape from the prison van. One sees a series of bail applications, all of which, again, actually is common ground to WL as well, have been rejected, even in circumstances where they were deciding these against a background of the only policy known to them, the public policy in favour of release. And again, in our respectful submission, it is quite clear that the Court of Appeal and Mr. Justice Davies really had no option but to come to the conclusion that they did, given the seriousness of the offences, given the circumstances of legitimate considerations to be taken into account in the context of detention, there was really no option. So this is...
Sorry, I just want to be clear what point you're actually addressing here.
The point I'm addressing is I've made my submission that as a matter of law, you have to find an effect or influence of sufficient connection. So I'm saying is, as a matter of fact, I can do this. And I really conclude by saying this is not a case where my lord or my lady have to look into a crystal ball and speculate. You have the court records here, the immigration judges, the courts below, and the like. It's not even a cotton case. My Lord Brown remembers the fat policeman case, as I do, where it's been said, well, actually the fact he wasn't given a hearing before he was dismissed from the probationary service and made no difference because they had a weight lift and he was fat. Alas, and that was it. That isn't this type of case at all. One goes beyond this. The courts always look, if they can, to facts rather than to speculate, and we're not inviting you here to speculate. Now, can I then come, and I'm very conscious, I hope perhaps rightly, of the fact that we've put, as it were, the most attractive solution first, in our potential solutions, not least because we're aware that it has some not inconsiderable sustenance, not only in the reasoning of the courts below, but in cognate cases that we've sought to refer to. And I think, bearing in mind the time and bearing in mind one has other issues, could I, as it were, ask your lordships and my lady simply to be good enough at your leisure, as it were, to read or reread, because I'm sure you've done us the honour of reading the printed case before, just to reread those. As I say there, it may be, perhaps I'll just touch on 3, perhaps not just because my Lord President reminded me, that there were circumstances in which courts have already, as it were, retreated to what I call a pre-anisminic analysis for reasons that obviously reasons that were pragmatic reasons. And can I just ask you to look, if you would, at paragraphs 10.12 and 10.13, 14 and 15 of our printed case at paragraph 65, and just say there were 2 cases which we illustrate. One, the Court of Appeal deciding that though judicial review could lie to challenge the decision of a circuit judge refusing permission to appeal from a district judge's decision, the jurisdiction should not be exercised, except as was put in very rare cases where a litigant challenges the jurisdiction of a circuit judge giving or refusing permission to appeal on the ground of jurisdictional error in the narrow pre-anisminic sense or procedural irregularity of such a kind as to constitute a denial of the applicant's right to fair hearing. And one understands the second because that's, as it were, intrinsic to the justice system. And then the Civic Subramanian model, which is the one I just referred to, was imitated or replicated in the case of Cart, which I believe is on the way to this court. But nonetheless, Lord Justice Sedley then, looking at the extent to which the new upper tribunal could be judicially reviewed in the High Court, drew attention to the fact in the first sentence that we've quoted that there is indeed, as I submitted earlier, a true jurisprudential difference between an error of law made in the course of an adjudication which the tribunal was authorised to conduct, or I would say by analogy, in the course of a decision which a body is authorised to take, and the conducting of that adjudication without lawful authority, without lawful authority, as it were, in the secondary Wensbury sense. Well, in fact, actually, I think he's there saying, as it were, without lawful authority at all. He then goes on to deal with errors of law within jurisdiction. But he says, in the conclusion reached by the Court of Appeal, outright excess of jurisdiction by the upper tribunal and denial by it of fundamental justice, should they ever occur, are in a different class. They represent the doing by the upper tribunal of something that Parliament cannot possibly have authorised it to do. So, one has two illustrations in recent law of two courts in discrete situations recognising that to apply the entirety of the Annus Minute canon is not constant with pragmatic considerations or indeed justice. And all we say is, if one's able, as it were, as a court, to parse or qualify or categorize or segment those various principles, once the door is open to that, then one has to ask the question, is this another such situation in which it would be appropriate to follow the same route? And then finally, I just want, because my Lord Roger addressed the issue to me, it is in our respectful submission clear that going back to as we just called, I hope rightly, the classic statement of Lord Radcliffe in Smith and East Ellerway, we deal with this at 10.19 through to 10.23, that's at 66 through to 67 of our printed case. What he effectively said is, as we know, the fact that something may be a nullity doesn't mean that one doesn't have any legal consequences. As he put it so elegantly, it bears no brand of invalidity upon its forehead unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it crossed or otherwise upset. It will remain as effective for its ostensible purpose as the most impeccable of orders. And in Boddington, Lord Irving, the then Lord Chancellor, again referred to the fact that any presumption in favour of legality has to be overcome by a litigant before a court of competent jurisdiction, before it becomes of no legal effect whatsoever. So that, again, we say, may be a route out, because if these matters were then confined by procedural device to judicial review court, one would then be able to link the question of the availability of damages to the degree of influence, if any, that the public law flaw had on the particular decision. And we do say, and I've answered Sir John Dyson on this, so I merely repeat, so I remind my lords and my lady, there is a difference that the law has always recognised between a shield on the one hand, which is the Boddington and Wandsworth and Winder situation, and a sword on the other, because the defendant has not commenced the proceedings in which the lawful of the measure is in issue or chosen the forum in which those proceedings are to take place. In contrast, proceedings commenced by a claimant are under his control. So that would be the principal reason. The others are let, if I may, bearing in mind that I've got to concentrate on the points perhaps of which require oral elaboration with that. And can I just then, before the short adjournment, deal, if I may, with the last way of putting the matter, which is that causation as an ingredient of an award of more than nominal damages. Here, we are in perhaps a somewhat peculiar situation. If you look at the statement of facts and issues, we understood that what the Supreme Court was to be concerned with was the issue of exemplary damage. We make no complaint about that. Everything is now up for play, and we've been sufficiently alerted in the way in which it's been put. So we've got three issues: compensatory damages, if no compensation, what one might call vindicatory damages, and finally exemplary damages. We say that damages for false imprisonment, certainly of a compensatory kind, should include a causation test, because if in fact the same result would have eventuated if the correct published policy had been applied, one asks the question, not merely rhetorically, what actually have these appellants lost? We've dealt with that in our printed case at 10.24 to 10.29 at page 68 and following, and the Court of Appeal dealt with it at paragraphs 91 to 96 in the Weekly Law Reports, first volume 2010 at page 2204. May I make it clear that this is a fallback position? Obviously, the preference of the Secretary of State would be for your lordships and ladyship to find there was no false imprisonment at all. But a half loaf is better than no loaf, and in those circumstances, as it were, this would be the second or alternative position. Now, what we have dealt with in our printed case, if I can just summarise, because I'm anxious just to deal with two cases that were referred to by my learned friends in contradicting to that. What we have said, can I just summarise, just starting at paragraph 10.25. What we say is, firstly at 10.25, most of the cases involving damages of false imprisonment have actually concerned situations in which the individual would not otherwise have been detained, certainly. Evans is obviously an example. There's actually an interesting case, but we don't, alas, have time, the Iqbal case. It's in volume 20 at page 203. What had happened there was that because of the strike of the prison officers, Mr. Iqbal did not have his ordinary day's release for exercise, etc. He was locked in his cell for the entirety of the 24 hours. And one of the questions, it having been determined that there was no false imprisonment, that's a matter that hasn't come before the court, they turned to the issue of damages. And what is interesting is, in particular in the judgments of the Master Rolls, Lord Neuberger, paragraphs 48 to 49, and Lady Justice Smith at paragraph 83, is that they did take, as it were, a fact-sensitive approach. They said, in effect, what has he lost? He's in prison anyhow. Yes, he has lost something that he would ordinarily have enjoyed. So we'll give not a nominal sum, but something to reflect the reality of the position.
The appellants rely on, I think, the last sentence in paragraph 83, which is Lady Justice Smith saying, for false imprisonment there should always be damages based on normal compensatory principles. But you would say that goes too far, do you?
Well, no, what I'm saying is that what she's saying is, as it were, they have actually lost something here. I mean, it is a damage-specific issue. I mean, I think she's simply making a statement that ordinarily one would have found. Someone would have lost something. And she certainly conditioned the amount by the fact that the loss was the loss by a prisoner who's already incarcerated of, as it were, the residual liberty that one enjoys within a prison. At 10.26, what am I doing now? Yes. At 10.26, we refer to two observations, one of my Lord Sir John Dyson and one in the Roberts case, Lord Justice of Appeal at that stage, who actually had some doubt about whether or not one should ever award substantial damages if the same result would have happened anyhow. Lord Justice Clark, as it were, swallowed his doubts, though the Court of Appeal in this case wondered why. We refer at 10.28 to Lord Griffiths in the Murray case in the House of Law, that if one was, as it were, unaware that one had been falsely imprisoned and suffered no harm, no more than nominal damages. So again, in our respectful submission, what Lord Griffiths was saying is that the importance of personal liberty is reflected in the finding of a tort, but doesn't extend so far as to awarding substantial damages even where there is no real loss. And in our respectful submission, although of course this is not a case of unawareness, as Mr. Hussain said, of course they were aware of their detention. The real issue is actually did that detention, did it, as it were, flow from, was it in a different position? Were they in a different position to that which they would have been in any event? And on Lord Griffiths' analysis, if no, in our respectful submission, there would be nothing further. The Court of Appeal, finally, at paragraph 95 of their judgment, referred to a case in the European Court of Human Rights, which called Wassink. It's at paragraph 95, and you see it's at page 2204. And what is said there, and we'll hand it in if we may, perhaps have it handed in over the short adjournment so your Lordship may be not disrupted. But what you will see is, although that case, as you will see, was the result of detention through procedural error in the way in which the court order was made, what they did say in relation to Article 5.5, just turning over from the citation at 2205, it does not prohibit, Article 5.5, contracting states from making an award of compensation dependent upon the ability of the person concerned to show damage resulting from the breach. So we say that Strasbourg has also recognised that actually if you want to go on to claim damage resulting from an admittedly flawed detention, then you must show that you've actually sustained some such loss.
Well, my understanding in the SK case was that Mr. Hussain entirely accepted that, which is why he was putting his claim at common law rather than under Article 5.
So be it.
And he's nodding.
So be it, yes. Well, there we are. Is there just time to just refer, because I can literally refer to it and give you the answer to the Kuwait case, but if your Lordship prefers that after the adjournment, I mean, I've got perhaps no more than a minute.
We'll adjourn now and have your minute at 2 o'clock.
Thank you. Can I just say one thing? Of course, as you know, we had a timetable arranged, which I would get to my feet at midday yesterday. That was the agreement. Mr. Hussain very kindly, perhaps a pat Faustian or otherwise, said the additional time would eat into his reply, so that your Lordship, my lady, should not be concerned that he's not going to be given the time that he expects in reply. if that is a concern, I dare not. Thank you very much.